Okay, so heading into the jury system, right? So we know what the jury system generally is. We're gonna look at the composition of the jury system. We're gonna look at what the jury system is for. We're gonna look at how do we dismiss, right, jurors. What is the characteristics of a juror, stuff like that. We're gonna be looking at that. So the composition, right? So the juries typically consist of generally 9 to 12 individuals, right? So they're usually these groups of persons that you see mainly in criminal proceedings, right? So mainly they're using criminal proceedings, right? So the number of jurors can vary, so it's generally 9 to 12 individuals. So they're usually a group of ordinary citizens selected from the community where the trial takes place. So it helps within representation, right, of the community. The selection process now, we know that prospective jurors, right, have to be eligible in some way, right? They're summoned to the court and screened for eligibility based on certain criteria such as citizenship, their age, absence of disqualifying factors, right, such as criminal convictions, etc. Right? I think I have the Jury Act of Jamaica in the other room, but I'm not gonna go for it to read through. It's fine. It's fine. Not gonna go for that. I saw it this morning. But generally, we're gonna be looking at these different things that the jury, right, must have, right? So the characteristics of a juror. Okay. So what allows them to be qualified. That's generally one of the things that we need to look at. All right. So the challenges of the jury system now. The jury system, while crucial for ensuring fair trials and community participation, there are actually several issues with the jury system. Well, actually, a lot. So there's a lot of issues, right? They have peremptory issues and they have causative issues, right? So the challenges of for cause. So we're looking at those types of challenges, right? So they have limited grounds for challenge, right? So the grounds for challenging jurors for cause are not often narrowly defined, typically including factors such as bias, prejudice, or an inability to render an impartial verdict, right? So providing these factors to the satisfaction of the court can be very challenging. So it can be challenging to prove these things from jurors, right? The subjectivity in determination, right? Assessing the impartiality of potential jurors is inherently subjective and may depend on the judge's discretion, right? So this subjectivity can lead to inconsistencies in the application of for cause challenges and raise concerns about fairness and due process, right? So depending on the judge, the jurors that he keeps or she keeps may be different from the jurors that other judges may keep, and that will lead to inconsistencies, right? Time consuming process. Jury system is a very time consuming process. The voir dire proceedings, right, to determine jurors, right? So basically, we look, right? So basically, I look and say, right? So voir dire to say just French, right? The proceedings, right? For the eligibility can actually be time consuming. So the amount of time that we go through the processing the jurors can be a lot. Lengthy questioning of potential jurors may prolong trial proceedings and increase costs for litigants and the courts. We have strategic considerations as well. Attorneys may strategically use forecast challenges to remove jurors perceived as unfavorable to their case. This strategic maneuvering can lead to tactical advantages and disadvantages for parties, potentially affecting the outcome of the trial. Right? So depending on how good you are, you can try to you can actually remove jurors, right, that are unfavorable in the case, right? And that will lead to a lot of issues, right? So those are strategic considerations for the four cause challenges that we see. Yeah, the preemptory challenges now. What preemptory challenges are now are challenges of the legal mechanism, right? So legal mechanism that allows for attorneys to exclude potential jurors from serving in the jury without providing a specific reason of jurisdiction. So each party in the trial typically has a limited number of preemptory challenges, right, that they can use to remove jurors from a jury pool. So potential abuse. So attorneys can actually dismiss potential jurors without providing a reason. That's a peremptory clause, right? So while intended as a tool to ensure impartial juries, peremptory challenges can be abused to exclude jurors based on characteristics such as race, gender, and ethnicity, leading to discrimination or bias. We also have undermining diversity. Preemptory challenges may contribute to the underrepresentation of certain groups on juries, perpetuating systematic biases and disparities in the legal system. Attorneys' decision to exercise peremptory challenges based on stereotypes or prejudices, right, can result in homogeneous juries that lack diversity of perspectives, right? So it can be to the detriment or it can be used to their advantage, right? Undermining diversity. Challenge of impartiality now. The use of peremptory challenges, right, particularly when perceived as arbitrary or discriminatory, can undermine public confidence in the jury system's fairness and impartiality. So concerns such as bias in the jury selection may erode the trust of the league in the legal process. Right? So you're gonna lose trust in the legal process if you know that you're trying to have a jury of your peers, right? And they can just, manipulate the percentage of the jury like that. So it allows the citizens to actually lose trust in the entirety of the jury system. You have legal reforms as well. So some jurisdictions, right, have actually implemented some reforms to address challenges associated with peremptory challenges, right? Such as limiting their number, requiring attorneys rather to provide reasons for their use, or prohibiting challenges based on certain protected characteristics, right? So that's trying to limit the amount of peremptory cause challenges that a attorney can make. So how can we discharge a juror? The grounds for discharging a juror from a panel may vary depending on the jurisdiction and specific circumstances of the case. So I have drunkenness, right? So we know that intoxication can impair the judgment of a juror, right? So in the influence of alcohol or any type of drugs or anything like that, impaired mental capacity can actually allow for a juror to be discharged. Illness as well. So if the juror becomes ill or incapacitated during the trial, making it impossible for them to continue to serve the jury, they can be discharged. Severe illness or medical emergencies may require immediate dismissal to ensure the juror's well-being. We also have lateness as well. Jurors are typically required to arrive on time for court proceedings, ensuring the efficient operation of the trial. If jurors consistently arrive late or fail to report for jury duty without valid excuse, they may be discharged from the panel for neglecting their duty. Right? We also have accepting bribes as well. Right? So if they accept any bribes or gifts from any party that may influence the decision of the juror can be discharged, right? So accepting bribes undermines the integrity of the jury system and compromises the fairness of the trial. Alright? We also have having close relationship with the defendant. If a juror is related to the defendant by blood or marriage, or if they have some close personal or professional relationship with the defendant, they may be discharged, right, from the panel. So close relationships can create bias or appearance of bias, compromising the juror's ability to not to retain, but to remain impartial, right, and render a fair verdict, right? So we're looking at those type of things that can allow for the discharge of a juror. We also could look at the disadvantages of the jury system, right? So we have corruption of the process. One significant disadvantage of the jury system speaks to the potential corruption, right? The jurors may be subject to bribery, intimidation, or coercion, right? Leading to a bias or unjust verdicts, right? So one example of this could be Nanan v. the State, 1986, right? And that's a Trinidadian case. Okay? So that's an interesting case you could look at there. So basically, after a unanimous verdict of guilty, right? For I think it was a murder trial, right? Four of the members of the jury swore to an affidavit that the verdict was not unanimous since the foreman had not known the meaning of the word unanimous, right? So we have issues like that. So we have errors like that coming from there. So we have corruption. So generally, if there are any issues, right? Lack of understanding, right? That actually perverts the entire process, right? We can have the corruption of the process like that, right? So usually jurors are not educated on the points of law, right? Therefore, these issues can occur, right? They can be easily succumb to any type of influence or intimidation that can actually override the entire legal process and corrupt it, right? So we have that there. Problems with representativeness, right? So we could look at that. The composition of juries may not always reflect the diversity of the community. Certain groups, such as minorities and marginalized populations, may be underrepresented in juries, impacting the fairness and impartiality of trial proceedings. Right? I don't have a case here, but obit a dictum from Lord Denning, right, who complained that jurors are predominantly male, middle-aged, middle-minded, and middle class. Right? So it lacks in diversity. So the juries tend to lack in diversity in that case, right? So usually those persons would show up, right? So we're looking at the lack of representativeness, right, within the jury, and we know that the jury must be a culmination of the or of representation of the peers within the system, right? Within the community or the society in which the crime was committed. We have questions of race and ethnicity, right? So race and ethnicity can influence perceptions and biases among jurors, affecting their judgment and decision making in the courtroom. So looked at research, right? Research has shown that racial and ethnic minorities may face systematic discrimination, right? So looking at the discrimination right there, I think a lot of persons here could speak to how race and ethnicity affects, right, the jury system or affects the legal system, right? How does racism, colorism, and those type of things affect legal proceedings, right? It's really important to note, right, when you look at the disadvantages of the jury system. All right, gender inequality as well, gender bias, right, can also affect the jury system. Gender inequality in the jury selection and deliberations may contribute to unfair treatment of the parties involved in the trial, particularly in cases involving gender-based violence and discrimination. Right? So usually studies indicate that male and female jurors perceive evidence differently and reach different conclusions based on gender stereotypes. So Rojas versus Berialak 2004 is an important case there. Does anybody know what happened in this case? What happened in this case? One. All right. So with this case, basically, right, what would have seen here in this with these jurors in, I think, Gibraltar, is that the entire jury was filled with men because women weren't necessarily liable to serve, right? They were not compulsory to serve, but men were compulsory to serve. So men from the ages of 18 to 65 were compulsory to serve, while no women were compulsory to serve. So I end up with a list of around what 6,000 men to 25 women. So majority of the cases would have been filled with just male juries, and all male juries would have been seen as some type of impartial jury. Wouldn't be fair. Wouldn't have been an essential wouldn't it would have been an essential I would say no ingredient for inequity, basically. Right? So we're not gonna have that there specifically. So the entire jury was just men within this case, right? And they were seeing that this was not a full representation of the surroundings, right? And something had to be, changed, right? A non-discriminatory method of complete of mm, of compilation list was essential ingredient for the fair trial of an impartial jury, right? So looking at that, right? So non-discriminatory. So you usually have a mixture of men, women, right, different races, different ethnicities and stuff like that. But in this case, it was just all men. So we have that issue there. Misdirection of the jury, right? So jurors may be susceptible to misinformation and misdirection during trial proceedings, leading to errors in judgment and misconceptions about evidence presented. Factors such as complex legal concepts, emotional testimony, and biased arguments from attorneys can influence jurors' perceptions and decision making, right? So remember, jurors are judges of fact, not judges of law, right? So they will make these decisions, right? And actually get misdirected within the entire course of the entire litigation rather, right? So we have that there. For the misdirection of jury, though, we have the Sukram situation, right? It was stated out in 1971 in Sukram VR for this issue. So the judge may make inappropriate remarks which can influence the jury during the trial. He may be antagonistic to the counselor or and unduly criticize him, right? That can lead to some amount of issues there. The judge may inadvertently influence the jury in his summing up. He may seem to point to a verdict, right, in a particular way, right? So he can point to a verdict, right, that may pervert the process. The judge may mistakenly leave an issue of law to the jury to decide, as happened in Sukram's case, or she may fail to lead an issue of fact, right, to the jury to decide, right? So it should be fact, right? So stuff like that can happen, and the jury may misrepresent the law when attempting to direct the judge rather may misrepresent the law while attempting to direct the jury on the law. Right. So these issues are seen in Sukram v. R. 1971, right? In Senevertine versus R. Right, 1936, and Thomas v. R. 1992. Right. So we have generally those cases for any type of misrepresentation or misdirection of the jury, right? Now we're gonna have a look at the advantages of the jury system. Specifically, jurors are better judges of facts, right? So while judges themselves tend to become more complacent and look only on the law itself, right? Jurors have a better understanding and not first-hand knowledge of the realities of being an ordinary citizen within the society. Their collective wisdom and common sense, as well as their understanding of just factual evidence, right, and factual determinations in the case, are priceless within these proceedings, right? So jurors being better judges of fact would be actually a benefit, right? So this broad-based approach to fact finding enhances the accuracy and reliability of trial verdicts, rather than just looking at points of law, right? We have participatory justice as well. The jury system promotes participatory justice. This is just speaking about the involving of individuals throughout the society, involving citizens directly in their legal process for them to know that they have some amount of contribution to legal resolutions and to uphold the rule of law and to protect the rights of fellow citizens, right? So the jury service fosters a sense of civil duty or civic duty, right, and responsibility, right, to show that they have some active role in the administration of justice within the society, and this allows for the preservation of democratic principles within the justice society, right? Moreover, when we talk about the inclusion of jurors specifically from diverse backgrounds, it allows the outcomes are more informed by a broad spectrum of perspectives, enhancing public confidence in the fairness and legitimacy of the legal system. Right? So those are the two main benefits of the legal system, right? The fact that jurors rather are better judges of fact, and we have participatory justice, right? So those are the advantages of the jury system. We looked at the disadvantages to the misdirection of the jury, gender inequality, questions of race and ethnicity, problems with representativeness, corruption of the process, right? And we also look at the different reasons why they can be a dismissal, right, from the jury, right, as well as the structure of the jury system, as well as the peremptory causes and the for cause challenges, right? So that is really it for the jury system. That is the review of the jury system there. All right. Any questions?